Okay, so let's try that again. Again, we looked at all those clauses. We're going to use judicial review to essentially give the federal government expanded power over the states, but again, it's constitutional authority. And what we're going to see as in the next section is where you have certain uh, executive actions, legislative actions that will define not only the type of federalism, but will give the federal government new tools to um, uphold their expanded power. All right, so we start again with the 14th Amendment, just as a quick way of illustrating this. Again, there is specific language in here that should give the federal government authority over the states. Later in our civil liberties unit, we're going to argue that this language is what makes the Bill of Rights apply to the states, because by definition, the Bill of Rights helps you understand what your privileges and immunities are. By definition, when you look at the Bill of Rights, it guarantees you certain due process rights. By definition, the fact that you're entitled to certain rights and that those rights should be equally protected and equally applied, is understood about that document, and the fact that no state shall violate that ought to make the Bill of Rights apply. Again, the court will come up with creative ways why they disagree with that initially. We'll have this position of, does anybody remember? It's called no incorporation. Do you remember me mentioning that yesterday? Eventually, through cases like Gitlow versus New York, through Hacklow versus Connecticut, we'll go through a whole series of cases. They will one by one apply the Bill of Rights to the states. But we will never get to a position of total incorporation. Do anybody remember where we are? This terminology will come up later. I'm just trying to see if you just were ignoring me yesterday or if any of it stuck. It's called selective incorporation, okay? So, make a note of it because, again, the more you do these kind of things, the more it will stick. But we could use the 14th Amendment to, again, talk about expanded powers of the federal government to apply the Bill of Rights to the states. I think that that's perhaps the more obscure example and one that we'll do more uniquely with civil liberties. So for that reason, again, we're going to focus on Brown v. Board. And again, the idea is we're going to use the language here in a court case in the power of judicial review to give the federal government expanded powers over the states, and in this case with Brown v. Board, to regulate, racial policies. What we're going to see again is that constitutional authority won't quite be enough. Some of it because of flawed language, some of it because the federal government needs more than just constitutional powers. It needs actual tools as leverage against the states. Okay? So, again, Brown v. Board we talked about yesterday. It's a series of consolidated cases, but at the center of these cases is a girl, Linda Brown, who basically has to go halfway across the state to go to a segregated school when the neighborhood and her friends, who are white, are simply going a matter of blocks away. And the question is, does that sound like equal protection? Does that sound like we are, giving everyone the same kind of equal treatment? The case itself is, and we'll look at this in a second, the case itself is also involving a revisiting of the standard set up by Plessy versus Ferguson. That had established precedent, and we've got to kind of look at that precedent. Law binds the court, precedent binds the court. Whatever a previous court has decided, and the constitutional logic that goes around with it, binds the court. In this case, they overturn it, and it does happen. It's not often that the court will overturn past kind of judicial decisions and the precedent that it established, but it does happen. And rightly so in this case. The court rules that separate but equal violates the Equal Protection Clause. I think they had grounds because, we're looking at the 14th Amendment. We can say, the amendment, as you look at this language, changes things. The previous court was wrong. They're not looking at the Equal Protection Clause the right way. Again, we talked about the phrase that kills it, with all deliberate speed. That all deliberate speed essentially allows states and districts to kind of drag their feet. You see, I mean, we've got a 1954 court ruling, and yet here we are 10 years later, and you've got fewer than 1% of African American children in the South attending integrated schools. Prince George's County, which is a stone's throw from Washington, D.C., and the nation's capital where this decision was made, elects to close down its public school system rather than integrate. So what you see here is that this is not necessarily enough, and that's kind of what we'll get into in the other half. The first half we're looking at, just the power of judicial review to give expanded power, but it's constitutional power. You need other powers. So, for example, and I've kind of resequenced the notes. Oh, I thought I put it there. Yeah, I did. For example, what you also need to make this happen is the Civil Rights Act. And with the Civil Rights Act, I have the Attorney General and the Equal Employment Opportunity Commission as governmental authorities that have the ability to uphold that law. And they do it first and foremost by monitoring. Again, I want you to picture just the power of the public spotlight. Again, after Ferguson, where we began to kind of look at the idea of our police, using excessive force and doing so, in a disproportionate way against African Americans. The Justice Department went in and looked at that shooting of Michael Brown. They monitored and investigated the police department. That brings a lot of public pressure, and any kind of report that they issue is going to bring a lot of pressure, let alone the fact that they could bring criminal suits or civil suits. So in that way, we can force compliance. In addition, we can use the power of money, and you're going to see that as well, right? If you go back to the General Welfare Clause, where in the New Deal cases, where the courts gave the federal government the power to use the power to tax and spend to induce, as long as you're not coercing, what we begin to see is the use of, do you remember, grants and aid? I don't know how clear I made this yesterday. Do you remember the two types of grants and aid? And then we'll talk about the two types of one of the two types. The government is just mean sometimes.
Block grants.
Good. So block grants is one of the two types. And categorical. Good, you got it. All right. So there's categorical and there's block. Do you remember the two types of categorical? Where I'm giving money for specific purposes.
Project and formula.
Say it again? Project and formula. Good. So, again, when you look at project grants, it's for a specific kind of purpose, and there's an application process, a competitive bid, and we look at those bids and we award the money to the best bid. With the formula grants, again, that's by formula. So in other words, there's this legislatively prescribed kind of condition that makes money automatic. And we looked at yesterday that in part is where most of our money is tied up. It's very hard to reduce the federal budget if you've got kind of mandatory spending. You've got entitlement programs, for example. The block grants, again, here's a big chunk of money with less strings, with a finite amount. Therefore, who likes this better? Who likes the idea of less strings and a finite amount? The conservatives, right? So, at any rate, that's all background in terms of like how we might allocate money. But the bottom line is, you might get some questions about the different types of grants and the effectiveness of the types. But bottom line is, in one way or another, I can use those as a carrot and stick. Comply with some of the benchmarks and goals we've set with in terms of desegregation, and we'll give you money. Okay? So do you think you have kind of the transition we're about to make, where we're not just going to look at judicial review now, we're going to look at the other type of government action. What is the executive and legislative branch doing to claim expanded power? As a backdrop, most of we're going to kind of look at different presidents, different kind of eras, and the approach to federalism at that point. So I could just in a vacuum say that federal power expands or contracts because of governmental action. There's a larger context though. What we have outside of that, governmental action is historic events, social pressure. So I just want to remind you that there's a larger context to this, and there could be a layered question. I'm not talking about one specifically that's coming for you, but I can envision one where you not only have to kind of talk about the expansion of power, but you have to talk about it as being in response to social change. So you'd have to bring in the context. Does that make sense? All right. So, a lot to juggle there. At any rate, what we're going to do is kind of one by one look at different periods of time where there's a different approach to that division of power. It's given a name, and you want to be able to illustrate it with specific kind of, exemplars. And you did a lot of that work in your key term work. The first two types start as cakes, and the metaphor kind of works. The first type is called dual. They got all different names again. It's like we're back to enumerated and listed, and I don't know why they just don't stick to one name. They like to try to knock you guys out of the 5 range, I think. So the first type is called dual federalism. It's also called layer cake federalism. If we use the layer cake analogy, what you have is 2 delicious layers of cake as separated by frosting. And never shall the 2 layers of cake meet. Okay? Cake. So that's the analogy, because the next one is going to be marble cake. And what you see is a kind of a delicious swirl and mixture and integration of the 2 levels. Right now, they're separate by a layer of frosting. They're dual. They're parallel institutions that are autonomous and separate, okay? So what the exemplars what the policies that help illustrate this approach to the federal government are cases where the federal government could have taken more power but elected not to. My examples are kind of the negatives. Starting with Dred Scott versus Sanford. And the video went over that. Hopefully you guys remember it. This was a case of there's an army surgeon who has a slave. They start in Missouri. They go to Illinois. They later on go to Wisconsin. These are free states. And upon the death of the surgeon, Dred Scott basically sues for his freedom based on the idea that he had been in free states. Part of the retroactive kind of suit was based on the idea that his ownership is now going to be transferred, and he's looking for the opportunity to. I don't know if he was basically saying I didn't sue before because the army surgeon was an acceptable situation, or if it's just because now there's an opportunity. It's one of the two. And I don't think it's completely central. What we want to know he's suing, and it leads to the Dred Scott case as decided, as presided over by Justice Taney, and it's like one of the most abhorrent decisions ever there was. What they decide is kind of a 3-part decision. There's 3 kind of bits of awfulness to this. The first bit is the idea that Dred Scott has no grounds for suit because only citizens can sue and have legal standing in the United States. And under the Constitution, African Americans were never intended to be citizens. So you have no grounds to bring suit. That's the first bit. And consequently, we could kind of end the case there. You're going to remain a slave. But we go on because the case is also looking at not just the legal grounds for Dred Scott's suit, but it's looking at the law that he is challenging in particular or using as part of his challenge, and that's the Missouri Compromise. The legal basis for his suit is above this parallel is free states. And so as the court looks at that, they decide that the federal government has no authority to regulate slavery in the states. There's this idea of a right to contract. There's this idea of a right to property. And essentially the federal government is violating those laws according to the Taney court. And it negates the Missouri Compromise. That makes sense? You have right to property. And that supersedes the federal government's authority to create, areas in the country that are slave state and free state. again, a pretty distasteful verdict. And what you see here is that the federal government had the chance, the court had the chance to regulate slavery, to uphold the Missouri Compromise, and make states comply with it, and they did not. All right. So again, with dual federalism, with layer cake federalism, what you want to see is that the levels of government are separate, they're autonomous. The federal government is narrowly defining the scope of its authority according to the delegated powers, and it does not take opportunity to get more power. Dred Scott's a great example of that. Plessy versus Ferguson, another distasteful case, is a great example of that as well. And we intimated about this. We talked about, we did it out of sequence. We did Brown v. Board in its overturning of the precedent set, the standard set in Plessy versus Ferguson. So we'll rewind on that. Again, what we're looking at, what's being challenged specifically is segregated facilities on rail cars. It's challenged by a guy named Homer Plessy. He's 1/8 African. This is a deliberate effort to challenge the law. This isn't just happenstance. The idea is the 1/8 African American is so inconsequential. It shows you the arbitrary nature of this law. If there is no, when you look at them, if you can't make a physical distinction, you can't make really a genetic distinction, this law is arbitrary. What is the distinction? Why are we doing this? Is in part why he's kind of a perfect person to be picked. At any rate, what we're challenging is the 13th or what we're using as grounds, is the 13th and 14th Amendment. I don't think you necessarily need to know all the court's rationale. With Plessy versus Ferguson, what you can get to is the idea of separate but equal. But I think it's helpful and informative sometimes to look at the language of the court, just to see, because I guess this is what you're going to say. A lot of times people look at the court and they expect, that the court has some sort of intuitive powers that are greater than our own, and they're always going to arrive at justice. We hate injustice. It doesn't sit well. And what I want you to see is that sometimes, based on the time period, what you've got is justices that make decisions based on the composition of the court. The composition of the court has as much to do with the decision as the legal issues sometimes. So if you get conservative justices or liberal justices, that will influence the verdict. If you get justices that are mired within the kind of the time frame, that will influence the decision. So the composition of the justices has as much to do with the decisions as the law does, okay? Who's in the court? So at any rate, we're looking at the 13th Amendment. We're like, okay, that's, is that grounds to, desegregate? May not be as applicable as the 14th Amendment, but abolishing slavery and negating the idea of a secondary class of citizens ought to have some legal traction, right? What they basically say here is that this is a statute that implies a legal distinction between white and colored races. Legal distinction is separate than the idea of legal equality. This is just classification. We've kind of removed a legal classification. And even though we no longer have this kind of, institution of slavery, there's still going to be kind of, basic social inequality. That's the norm. And so you can't use the 13th Amendment to try to create legal equality in that sense. All right, so already we don't like the decision. Then they look at the 14th Amendment. And that's, you got equal protection in there. You got privileges and immunities in there. Due process may not apply, but you've got language in there that must apply. What they say again is that this is legal, that the language there is intended to deal with legal status. And again, the idea of political and social equality are two different things. If civil and political rights of both races are equal, one can't be inferior to the other civilly or politically. If one race is inferior to the other socially, the Constitution cannot put them on the same plane. I can't use the Constitution, they're arguing, to make you more tolerant and acceptant of each other, and therefore you can't use it. And what they're missing is, wait a minute, there is a legal distinction being made here by law. One group has to go here, and the other group has to go there. Okay? They've kind of, I think, obfuscated. They've kind of, sidestepped the issue. They're basically saying, hey, people are never going to kind of like accept each other socially. The law can't make you do that, and therefore you can't use it in this case to desegregate. And they're missing the big issue. But by law, you are segregating. All right. Long story short, remember the standard, and remember that again, here is an opportunity for the federal government to claim expanded powers over the states, and they elect not to. Okay. So we've got Dred Scott and Plessy versus Ferguson as two examples of opportunities not seized. And thus we stay separate, we say kind of separate and autonomous. And one other thing I want to kind of talk about. Not only does it set up this standard, it upholds the idea that segregation is something that can. It basically upholds the idea that the power to segregate and discriminate is a reserved power. One that should be left to the states. So not only do they not pick up an opportunity to claim more power, they specifically confirm state power and state autonomy. Okay? Now, the other ones are economic. And again, I think we can just get them in broad brush strokes. So the Interstate Commerce Act. What the boogeyman back then was railroad industries. They were kind of the lifeline of commerce at this point. And there's a lot of concern, like Northern Securities. I don't know if you remember studying that. That was the one that FDR did break up. He gets the reputation of trust buster, which is accurate. Did I say FDR? Teddy Roosevelt. Teddy Roosevelt gets the reputation of trust buster by breaking up Northern Securities, which was going to be a conglomeration and alliance of three of the biggest railroad industries around. It would be like Google joining up with Apple, joining up with AT&T. Would that send a chill through you? The idea that your lifeline in terms of communication with the outside world, the internet, was one big monolithic kind of company. So railroads were that back then. They had a stranglehold on essentially the flow of goods. Roosevelt, like I said, breaks them up, but he's also going to break up a coal mine strike. So he gets this reputation of trust buster, but remember, it's often more about imbalance to him. He just doesn't want imbalance within the economy. So he'll break up businesses, but he'll also break up a strike that he feels is a threat to national security. Long story short, we're becoming concerned about the railroad industry and things like I just talked about, the conglomeration of certain railroads. Teddy Roosevelt and his breakup of Northern Securities stands out so much because it's like the exception to the rule. It's the one time we begin to break up trusts. Otherwise, we don't regulate the economy as much as you've been kind of, as much as was suggested. Roosevelt is, like I said, immortalized as a trust buster. But what you see is, for example, you have the Sherman Antitrust Act, and all the regulation that they ever did of the railroad industry is overturned. 15 of their 16 rulings is overturned. They had authority on paper. It's like the Articles of Confederation. They could make corporate officials go to jail if they're involved in some sort of malfeasance, some sort of collusion. They can make guilty companies pay damages. They can break them up, but they don't. There's one occasion, like I said, Teddy Roosevelt and Northern Securities, and that stands out. But what people miss is, where are the other cases then? If he's a trust buster, where are the other trusts that he busted up?
Please excuse the interruption. If you cannot send your attendance the normal way, please try email or, as a last resort, send down a paper copy. Thank you.
Carrier pigeon, smoke signals, jungle drums. So the other example, too, is why do we need the Clayton Antitrust Act? If this was effective, if we were regulating back then, why do we pass another act that's the same thing with authority to break up trusts but has more teeth? So again, what I'm showing you here is we had an act that gave the federal government the chance to claim expanded power, and they didn't do it. They constantly shied away from enforcing their own rulings. Okay? And then I can do the same thing. Well, I can do it with the Interstate Commerce Act. I can do it with the Sherman Antitrust Act. I can essentially show you that there are two different financial powers, or bless you. Let me call it regulatory powers that they could have had to regulate states and industry, and they didn't take it. Okay. Now, from here, like I said, we're going to go to cooperative or marble cake federalism. So, do you feel like you have a good? It starts to get. There's a lot of layers here. So we're going to just kind of keep cycling through types of federalism. You've already tried to hold 5 clauses in your heads in the corresponding court cases, and now we're going to, again, move from the courts to the executive and the frame of governmental action. We good with layer cake? Good. All right, here comes cooperative. Cooperative is, and again, marble cake, like I said, is because you've got this inseparable mixture of delicious chocolate and vanilla cake. I think that's the only acceptable type of marble cake, correct? You can't do like strawberry and peanut butter. That's no good. Is there peanut butter cake? I think there is. Okay, so what we've got here is the 2 layers kind of fused, integrated. There's this inexorable, let's use that kind of big complicated word, inseparable, mixture. Again, remember I said there's a social context that surrounds this? Well, the social context that surrounds this is the Great Depression and eventually, World War II. Big, major crises that we are going to need more of a kind of a robust response to. We're going to welcome, in a time of crisis, we'll welcome a more, active federal government, okay? So the context that surrounds this is the Great Depression and the New Deal, which again, I have assumptions that you guys are fairly fluent in, right? So the New Deal, when we define the New Deal, I want the 3 R's in there, because it is a definite, phased kind of program. The immediate thing is stop the bleeding. Right? We have to triage. We have to kind of, just deal with the aftermath. So we go relief first. People are out of work. People are destitute. People are living in shanty towns, Hoovervilles. We need to bring immediate relief. But from here, we want to also begin to not just constantly, run soup lines. We want to eventually transition to something a little more stable. We want to move to recovery. We want to try to get back on our feet and move past just, putting the Band-Aid on the wound. So we want recovery. And then ultimately we want reform. We want to make sure it doesn't happen again, right? So relief is the immediate kind of, we've got to stop the bleeding. Recovery is we've got to kind of treat the patient and get them back on their feet. And reform is we want to make sure it doesn't happen again. And the way we achieve the relief, recovery, reform is through this series of that flurry of New Deal legislation. Anybody remember some of the nicknames for it? Because they all went by these acronyms. So I got a whole series of the alphabet soup programs, right? Because they all had the acronyms. It's not a bureaucracy. It was also called an alphabetocracy. I thought you were about to raise a hand and answer that. Just an itch. I got excited. So, all right, alphabetocracy, alphabet soup programs. And what you guys want to be able to do, I've got it later. There's a big list of them. What you guys want to be able to do is be fluent in them, right? I don't think every single program, but at a minimum 3, right? If you're doing a piece of writing and you want to indicate that the federal government during this time period claimed expanded powers, you could illustrate it with at least one, if not a couple of alphabet soup programs, right? Social Security, you got that one at least. The regulation of the banks, creation of the FDIC. Hopefully you've got, I would say a minimum of 3 just to be able to kind of, illustrate it and show some authority in this area. That flurry of legislation, again, comes, in a rush. It's called the 100 days. The context matters. FDR has a lot of political capital at this point. We're in crises, and we're willing to rally behind the executive, the single figure that serves as the face of the nation, and give him all kinds of political authority. And he uses that in a favorable majority in Congress to pass a flurry of legislation. This is new. FDR, transforms the presidency in a number of ways. One of the most profound ways is he essentially establishes himself as a legislative leader. We'll talk later on. Today, a majority about an equal number of legislative proposals come from the executive branch as they do the legislative branch. Again, it's that singular nature of the office. It's the fact that you've got a single individual who can act swiftly and unilaterally, and more efficiently sometimes, can use the public eye that they're under. What did Roosevelt call it? The ability to kind of use the public forum to force Congress to do things. The bully pulpit. They can use the bully pulpit to get pressure on the legislative branch. So at any rate, he becomes a legislative leader, and he passes or introduces, and then Congress passes all of these alphabet soup programs, right? Now, what I referred to yesterday, and I should not sprint through this section, so I'll just kind of set it up, and then I'll let you digest. The idea here is, again, what I hinted at. The federal government is going to try to make up for everybody is, not everybody, but we've got massive unemployment. We've got, a decline in our production. We've got, inflation. We've got all kinds of these problems. What we're going to do is have the federal government spend to make up for a lack of spending in the private sector. So we're going to do public spending to make up for a lack of private spending. And what we hope to do, like I said, is prime the pump. Again, what they're going to focus on is called Keynesian or demand-side economics. You're also going to see sales law occasionally. What it says essentially is demand drives supply. If the consumers are clamoring for something, businesses will figure out how to produce that thing because there's a financial incentive. So if I can stimulate demand, even if it's artificially through kind of public spending, I'm going to get businesses kind of back on their feet. They're going to be hiring. They're going to be producing. The goods eventually will come down in terms of price. That means more purchasing. That means more money to the businesses, and we prime the pump. All right. So remind me, we've got to kind of go over that demand-side economics a little bit more. We'll contrast it to Reagan's supply-side economics.
Jacinta.
Say goodbye to Ryan.
Erin O'Leary.